Okay, good afternoon, everybody. Thank you for joining me. And I think we're going to go ahead and get started here. Thanks for joining us for this installment of our OG Energy Education Series. The title of this presentation is Surface Rights, Game-Changing Issues Surface Owners Must Deal With. This is a presentation I had put together for AAPL actually at their request. And I thought it was a great topic, had a lot of fun putting it together and doing the presentation for AAPL a couple of weeks ago. So thanks to them again for proposing this topic. And I think it's one that's going to have a great deal of interest to particularly those of you with a focus on Texas, though I do touch on some other jurisdictions, and there are some other cases and slides and issues here that I think people are dealing with across a number of jurisdictions that I think you will find of some interest. I also hope that at least a few of you out there are dealing with solar companies or dealing with solar issues. The renewables sector is where a lot of the case law dealing with surface issues is developing, particularly solar surface use, where you're blanketing the surface of the land with, very land use intensive solar panels and other gathering facilities. And so a lot of the case law is kind of moving in that direction. And we're looking at a lot of instances where mineral owners and solar developers are having to play in the same sandbox and figure out ways to accommodate each other. As a quick overview of what I'm going to be talking about today, I'm going to start with what's known as the dominant estate theory, something that I'm sure many of you are pretty familiar with. Talk a little bit about estate owners' rights. And, this is something that I think it's good to go over just to provide some background, because there are certain parties that I've dealt with recently, for example, that come from places like Louisiana, where it's a very different approach. And sometimes they're very surprised to hear that a severed mineral interest from 100 years ago can still be outstanding and still have some say in how the surface is used. They can't understand that things don't revert to the surface owner every 10 years. So in Texas, of course, we don't have a lot of abandoned mineral type statutes, dormant mineral acts, things like that here. We don't at all. Some of the things that you might be able to use to cure issues, missing owners, outstanding interests in other jurisdictions just really don't exist here. So we've created kind of a unique statutory and a common law scheme. So I will also be talking about the Accommodation Doctrine and some recent developments there. A little bit about surface use agreements. And in that section, I will also talk a little bit about surface waivers and accommodation agreements, what those are, how they're being used. One of the hot topics right now is ownership of pore space and underground storage, particularly related to salt domes and caverns. So I'll touch on some of the recent case law there. And I will close it out today talking a little bit about water rights. So starting off, we'll discuss surface use and mineral severances. As you all know, of course, ownership rights in a tract of land may often be split between the surface estate and the mineral estate. This is sometimes referred to as a mineral severance and is a very common thing to encounter in Texas and just about every producing state. And of course, an owner of both the surface estate and the mineral estate can sell, convey, or partially convey the rights to either, or sometimes both, the surface or the mineral estate. If you own the surface and the minerals and you convey all right, title, and interest, that's going to carry with it, of course, both the surface and the minerals. Once things are severed, it gets a little more complex. New owners can, of course, then convey or partially convey their interests to new parties. And in practice, what you'll often see is that when you've got a whole lot of conveyances and small, numerous fractional interests in the mineral, you're usually talking about the mineral estate as opposed to the surface estate, because, very few people are interested in owning 5% of the surface estate. But of course, 5% of the minerals can be a very valuable interest. So something else you are, I'm sure, all familiar with is the legendary bundle of sticks. We all love hearing about the bundle of sticks, and I will briefly talk about it and why it matters here. So first of all, the surface estate owner is generally going to have the right to use and enjoy the surface, except for, of course, any surface rights that belong to the mineral owner. The mineral owner is going to have what's basically an implied easement to enter and use the surface, or as much of the surface as is reasonably necessary to develop the mineral estate. The mineral estate owner is going to own 5 sticks in his bundle. That is the royalty stick, bonus, delay rentals, which you don't see that often these days outside of certain federal and state leases, the executive right, which is the right to negotiate and execute oil and gas leases on behalf of non-participating owners, and what's known as the developmental right, which is the right of ingress and egress from a tract of land to develop the mineral estate. So the executive right holder, again, is going to have that right to execute oil and gas leases. And this is generally considered to be fused with the developmental right, but not always. So if you see a conveyance of the executive right, it's usually going to include the right to develop, but those rights can be severed as long as it's done specifically and with intent. So again, kind of a basic theory in Texas is what's known as the dominant estate theory. Again, this is something that sometimes coming from other jurisdictions, people are a little bit surprised to hear and surprised to learn how much latitude mineral owners have over how the surface estate is used in Texas. So when the mineral estate is severed from the surface estate, the mineral estate is considered to be the dominant estate, and the surface estate is considered to be the servient estate. These terms come from the law of easements originally. And again, it's this idea of an implied easement to use the surface. And usually when you're talking about easements, the easement is going to be the dominant right, and that you're going to have the right to cross over the surface, which is then servient, or at least that portion of the surface is servient to your easement. So that's kind of where these terms come from. So mineral estate owners, therefore, may make reasonable use of the surface in order to develop their mineral acreage without being liable for trespass or without infringing on surface owners' right to quiet enjoyment. This can be sometimes a shock to surface owners when they find out that a severed mineral owner or their lessee has the right to enter on to their new retirement ranch or property and drill a whole bunch of wells, and that they basically have to find a way to play nice with. So I've underlined the phrase reasonable use here because that's one of those inherently fuzzy terms. What is reasonable? Well, reasonable minds can differ as to what reasonable means. So then what is reasonable use? Well, the common law in Texas has essentially defined reasonable use as being geophysical exploration, so conducting seismic on the land, drilling, building roads, installing machinery, installing storage tanks, batteries, things like that. But the question becomes, okay, then does it cover everything? Is this dominant estate truly dominant or all powerful? And as a spoiler, it is not. So there are a few broad categories of surface rights that I'm going to be talking about today. The first are rights created under an oil and gas lease. This is often the first place you want to look when it comes to how much leeway you have to use the surface for certain proposed operations. It's a good idea to start with the lease. There's, of course, rights that are created under the Accommodation Doctrine. There's rights that are created by statute, and there's rights under a surface use agreement or easement. And often, even if you have certain surface terms set forth in an oil and gas lease, it is a good idea to have a surface use agreement as well, though sometimes surface agreements may be baked into a lease in the form of an addendum. You can see some very specific and lengthy terms in some leases dealing with surface use. So turning then to kind of the rights under an oil and gas lease. The typical lease grants the lessee the right to use as much of the surface as is reasonably necessary to conduct their operation, so to enter the land and produce the minerals. So this is generally going to include, again, exploring, prospecting, producing, drilling, mining, and seismic, these types of standard operations on the land in order to recover the minerals. Also, there's got to be takeaway capacity. So you're going to have the right to lay pipelines. You're going to be able to build roads, tanks, power stations, telephone lines, electric lines, all these types of things. And so you're going to have the right to lay these. Usually you get an easement agreement as well. And again, the more you can agree on the front end to different types of surface use, the less you're going to have to worry about on the back end. Pipelines, typically they're going to have to be below plow depth. You're going to have to be at least 200 feet away from a residence or barn. That can change a little bit, depending on the circumstances. And of course, what is reasonable may come into question. For example, how many pipelines are permitted? We ran into this issue a few years ago in New Mexico, actually, where our client had built several pipelines already, installed several. They wanted to build additional pipelines. The lessor really was looking to extort quite a bit more money out of them per rod. And they were trying to argue, they were trying to stretch the kind of very generic language under their lease. And they ended up, settling somewhere in the middle. But it can come into question. Well, can you just build as many pipelines as you want? Or once you've kind of built pipelines for initial operations, could you get theoretically some pushback on adding additional pipelines or takeaway capacity? So, and the question then becomes, at what point do you have to negotiate a new easement or surface use agreement and pay a whole bunch of additional consideration for that? And of course, leases, as I mentioned, may include many additional custom provisions. You'll sometimes see things in federal leases, for example, that protect certain species, the lesser or the prairie chicken, the sage grouse, things like that, different habitats, different areas that might have Native American artifacts, things like that. There's a lot of additional terms you might see in federal leases, for example, that deal with surface use. So then what is the accommodation doctrine? This is developed over time. In many jurisdictions, it is a creature of common law, though in some jurisdictions, it's actually been codified. I'll talk about that a little bit in a minute. But the purpose here is to seek to balance the competing interests of the surface owner's continued use of the surface and the necessity of ingress and egress for the mineral owner. So this is the court trying to strike a balance between these two interests. They're saying, look, you've got this dominant estate, you're allowed to enter the surface, but let's try to do it in a way where everybody can kind of get along and use the surface simpatico with each other. So one thing I'm going to point out here is this idea of continued use. And I'll talk a little bit about why that's important and why the accommodation doctrine is more of a shield than a sword in many instances. So here's what the accommodation doctrine is. And many of you out there have heard of the Getty oil case. This is kind of one of those seminal cases in Texas. It's cited too in a number of other jurisdictions. And this is sort of the source of the accommodation doctrine. So this is kind of, week one stuff when you're taking your intro to oil and gas law class in law school. So the facts in this case were that Getty was the oil company and Jones was the surface owner, and Getty had installed a pump jack to produce oil from the lessor's land. The pump jack extended about 17 feet into the air, and it was interfering with Jones's irrigation operation. So kind of similar to the picture I have below, this was a center pivot type irrigation system where the irrigation system moved around a central point on wheels in a 360-degree circle, and the pump jack was kind of right in the middle of that circle, so it interfered. And obviously, the irrigation system wasn't tall enough to, for example, pass over the pump jack. And importantly, this irrigation system had been there for some time, and it was really the only reasonable way that Jones had to kind of, irrigate his property. And so the court here found that Getty had reasonable low-cost alternatives to their pump jack. And, interestingly to me in this case, and some of you out there might have encountered this before, but the court's rationale was that Getty could have dug a pit and put their pump jack down in a pit so that the irrigation system could pass over the pit. Now, if you dig a pit with an irrigation system passing over it, it seems like you would probably have issues with water gathering in the pit. I don't know if this is really a reasonable alternative or not, but the court said, look, you could bury your pump jack. And so in this instance, Jones won out and the accommodation doctrine was born. So what is the Getty oil rule then? Well, if the proposed use of the surface by the mineral owner will substantially impair existing surface uses, and if the mineral owner has reasonable alternatives available, the mineral owner may have to accommodate the surface owner. So again, do you really want to be judged by this standard? There's a lot of reasonables and ifs and mays, very fact intensive. Probably not unless you have to. And this is why, coming to some sort of an agreement beforehand is always preferable. Again, I've italicized the existing surface use part here because this is an important distinction moving forward, especially for solar developers. And I'll explain, as I get more into this, I'll explain why. But the idea here is that it's very difficult, if not impossible, to use the accommodation doctrine preemptively to say, well, look, I've proposed a use here. I want to get a court to bless it, and say that my use is reasonable on the front end. it doesn't unfortunately really work that way, at least as it currently stands. So here's where the accommodation doctrine does currently stand in Texas. So first of all, like I said, the surface owner has to have an existing use. They have to have been making this use of the surface for some reasonable amount of time. The exact amount of time has never been decided by any court, but they're going to look at, again, a reasonableness standard here. The mineral owner's proposed use has to completely preclude or substantially impair the surface owner's existing use. Again, I'm going to use the idea here of solar panels. I mean, that's going to basically completely preclude or substantially impair the surface owner's use or existing use. And the surface owner is going to have no reasonable alternatives. The mineral owner is going to have alternative, reasonable, customary, and industry accepted methods available to develop the minerals. So again, what you're seeing here is this balancing act. The courts are saying, look, everybody has to get along. There's got to be at least enough room for the mineral owner to develop the minerals. But past that, the surface owner can basically do whatever they want. And of course, then it becomes a question of whether the mineral owner wants to come forward and claim that whatever, use, area for use or setbacks are not reasonable. One thing to keep in mind is that the accommodation doctrine may strengthen over time or after a surface facility is in use or in existence for a while. So the idea here is that, if you've been using the surface for a particular use or a particular, development or something for a while, then after a while, the mineral owner is going to kind of lose their argument. They're going to say, well, look, these guys have been here for a long time. It'd be completely impractical or onerous to have them come in and remove their surface use of their facility. And you're going to have to find some other way to develop your minerals. But again, this is not, they're still going to have the right ultimately to come in and develop their minerals. And what it may end up being is you have to remove a portion of your surface use, or you have to compensate them for the lost value of their minerals. So that leads nicely into the Midway solar case, which dealt with exactly these issues in West Texas. So here, a renewable energy company had constructed a solar facility that covered a large portion of the land, 70% of a 315-acre estate. I'll jump forward real quick so you can kind of see the picture here of the solar facility. And it covered, the entire central portion of the tract with a couple of alleged setback areas at either end. Importantly, in this case, is that oil and gas had never been produced from this tract. Not only had it never been produced, there was no history of leasing. Essentially, it had been, decades. It had been a very long time since anybody had sold or conveyed the minerals. And Midway probably got lucky here on these specific facts, because if there had been any use or any indication that these minerals had any value, I think this case could have come down a little bit differently than it did. So the plaintiffs here, which was the Lyles, sued based on the breach of a 1948 mineral deed, a theory of trespass, the accommodation doctrine, and quiet title. And the quiet title portion came into this because Midway Solar had gone around and taken a lot of surface waivers from adjacent owners in other sections. Many of these adjacent owners claimed to own an interest in the lands that were the issue here. It turned out after a title search, they didn't actually own anything. So Midway Solar had taken surface waivers from the wrong owners, and they were very little value. They were no value in this case. So that was the quiet title portion, was to remove the cloud on title that these other parties had placed by executing these surface waivers when they didn't actually own an interest. And so the Lyles were suing, of course, for monetary damages, being the complete value or the diminished value of their mineral estate and or removal of the facilities. The plaintiffs, of course, claimed that their ability to develop the mineral estate had been impaired by the construction of the solar facility, and that the accommodation doctrine should allow them to prevent any surface use that might one day interfere with the extraction of their minerals. So they were basically saying, look, we should be able to use the accommodation doctrine here because now we're going to have a lot of trouble developing our minerals, and they found an expert witness who came in and said, look, the only practical way to develop this tract would have been to put a vertical well right in the middle. These setbacks at either end don't really help my clients or, the Lyles here, because nobody's going to come drill a horizontal well. You look at the surrounding activity, you look at the historic trend line, you look at kind of everything that's been going on around here, and there's no way anybody's going to come, spend the capital to drill a horizontal well. If anything, it's got to be a vertical well, and it has to be right smack in the middle. You can shop for an expert witness to testify to just about anything you want. So what the court here did, however, was they said, look, Lyles, you did everything right. You're right. This is an accommodation doctrine issue. Midway Solar should have to accommodate your mineral interest, but the court made a kind of interesting move here. They said, look, this is really a ripeness question. They said, under these facts, until you seek to develop your minerals, Midway really owed you no duty respecting the surface usage. So what the court said here was, look, you've never actually tried to do anything with your minerals. Therefore, you really have nothing to argue. These minerals are essentially valueless, or put differently, we have no way to value the minerals. So you have no real world damages here. And if you kind of take a step back and look at this, there's an argument that maybe the Lyles were, trying to extort some money from Midway Solar. They said to themselves, look, we've got these valueless minerals. This solar company with deep pockets has built this facility here. Maybe this is the way we can squeeze some value out of these minerals. I'm sure they would have been very happy to walk away with a generous settlement, and settle the claim that way. But that's not what happened here. The court said, look, you never developed your minerals, you never leased, you never did anything. Now, if the Lyles had maybe executed a lease in the last 5 years, if they were presently negotiating a lease, if the facts had even been a little bit different, I think this argument would have come out differently and would have proceeded forward in the courts to try to decide if there had been a reasonable accommodation here or not. So the lesson is, particularly for you solar developers, there is some risk of going ahead and building a solar facility without waivers or accommodation, even in areas where there hasn't been a lot of production, unless, you're kind of under these exact facts where there's never been anything done at all. And even then, it's questionable as to whether this case would come out the same way under even a slightly different set of facts. So again, the takeaway is that you're going to want to try to negotiate service waivers or accommodation agreements on the front end with as many of the owners as possible, even if, very rarely is it going to be 100%. The other takeaways are that the mineral owner obviously can't have unilateral right to dictate the use of the surface. The theory of the dominant estate is, of course, not absolute. And again, the court said, the accommodation doctrine absolutely applies under these facts. We're just not going to apply it here. And again, the question I think becomes, then what does seek to develop mean? Do you have to actually be currently conducting operations, negotiating a lease? What if you had just tried to market your minerals in the last several years? What if you had been approached by mineral buyers? So this idea of what constitutes seeking to develop is still kind of an open question. And again, it's the reason why I think it's dangerous to rely on Midway Solar for the proposition that you can just go in and build, a solar facility or some other surface intensive use without seeking accommodation agreements first. So another kind of interesting sidebar in Texas law that's not talked about a lot is what's known as the Texas Qualified Subdivision Statute. And this is kind of an exception to the common law accommodation doctrine. And it provides a procedure for surface estate owners to limit the mineral owner's use of the surface based on the surface's future development. And it delegates administration of this to the Railroad Commission. So basically what's happening here is it's a statutory mechanism to do exactly what I was saying earlier that you can't do under the accommodation doctrine, which is use it as a sword instead of a shield and get, somebody to bless it on the front end and say, yes, this is reasonable accommodation. We're going to allow this to proceed. So a qualified subdivision is created by filing a plat for approval with the Railroad Commission and in the county. The biggest problem with the QS is that there's a residency requirement. So the idea here is that it's to allow surface development and mineral development to coexist in densely populated areas. And so to qualify, you have to have 400,000 residents, or you have to be in a county that's adjacent to a county of 400,000 residents with at least 140,000 residents. So kind of specific. It has to be for a residential, commercial, or industrial use. And there has to be a designated 2-acre drill site for every 80 acres and allowances for road and pipeline easements. So what you do get from this is an idea of what an accommodation agreement should include, even if it's being negotiated and not under the qualified subdivision statute. I mean, you're going to want to have, tracts, setback tracts, development, drill site tracts that are probably at least a couple of acres, maybe a little bigger. And they're going to have to be sort of checkerboarded or interspersed throughout the entire area of interest. And you're going to have to allow for access and takeaway capacity. And under the statute, though, the Railroad Commission will then have a hearing to determine the adequacy of the operations and everything else. And just note that based on at least the latest census, that, you're limited under this statute to about 35 of the 255 counties in Texas. And they're mostly going to be surrounding places like, Dallas, Fort Worth, Houston, San Antonio, Austin, some of the larger cities. And as you get more into the rural areas, the availability of this statute falls off quickly. There's one case, at least that's gone up on appeal, that interprets the statute. And here, SWEPI took issue with the fact that the Railroad Commission had allowed two contiguous tracts to be developed. And what they were leaning on here, if you go back real quick, was this idea that a single tract can't be greater than 640 acres. And then they also argued that a landfill was not an industrial use within the meaning of the statute. So they lost on both. The court said, look, nothing says you can't have two qualified 640 acre tracts next to each other, so that's a losing argument. And the court notes that the statute is intended to maximize surface use and mineral use in these population dense areas. And also they said, look, there's really not a good argument that a landfill is not an industrial use. So that seemed like kind of a stretch of an argument anyway, and a little bit of a YOLO. Yeah. But either way, SWEPI lost on both counts, and the landfill development was allowed to proceed. And it's not too much of a stretch to imagine a solar facility then being an industrial use within the meaning of the statute. So if you otherwise met the requirements, then something like a solar facility development would probably be an industrial use. If a landfill is, then I'm sure there's a good argument that a solar facility is as well. There just hasn't been a lot of instances of anybody invoking this yet. So a couple of different jurisdictional notes. Colorado is a state that has attempted to codify the accommodation doctrine as opposed to just leaving it as a common law theory. And it's really the same thing. It's the exact same standard. There's a reasonableness methodology baked in, and you're going to end up with the same kind of fact-intensive inquiry under the statute of, what is kind of reasonable and necessary. There's got to be a pre-existing use. A lot of these same kind of ideas just in statute form. Now, New Mexico and North Dakota is another example of this, is a state that passed a Surface Owner Protection Act. And under SOPA, an operator, has to compensate the surface owners for damages and loss of agricultural production and lost land value, et cetera. And the idea behind SOPA is that it kind of forces you to enter into a negotiation for a surface use agreement. There's notice requirements, before you can enter the land. And in the event you can't come to a reasonable surface use agreement, then SOPA is going to impose kind of statutory fallback terms on your surface use, and you'll be subject to those as well. So it behooves everyone under SOPA or the North Dakota Surface Damages Act to, come to a reasonable conclusion and kind of move forward. But under SOPA, like kind of the dominant state theory, like accommodation, at the end of the day, under SOPA, an oil company is going to be able to enter the track and drill wells. It's just, how onerous are the terms going to be at the end of the day. So then we get to surface use agreements. So obviously, I think I've touched on this enough that everybody probably understands that the idea here is to work out a lot of these issues on the front end, allow parties to resolve competing interests, come to a voluntary agreement rather than through confrontation, litigation, or, relying on Surface Owner Protection Acts or things like that to protect their interests. These are heavily negotiated. I've got a whole laundry list of terms here that you might commonly encounter in a surface use agreement. These are often going to be very tailored to the particular owner of the tract. What are they doing with their surface? Is this kind of their vacation home, their kind of ranchette that they've spent their whole life, saving up for? And they're going to be obviously very protective of the surface. We've been in negotiations for these where a very high value was placed on different types of trees. If you damaged a tree, if you had to cut down a tree, you were going to have to compensate the owner. Even if you dug a trench and damaged the roots of a tree, and it could be proved later that that interfering with the root system eventually killed the tree, you were going to be liable for that as well. We've also seen a per hurdle negotiation, because apparently they loved the turtles in their pond and they kept getting run over on the road. So they wanted them to drive slower and quit smashing the turtles. And it was quite a bit of money per turtle. And another was that they had an issue with, people out on the well site kind of, using the restroom openly on their property. And so that was a penalty as well. There was a fine baked in for that if they caught somebody out doing that. Apparently it had become a real problem, and it was within a, viewing distance, easy viewing distance of the house. So then we move to a slightly different but similar concept, which is surface waivers and accommodation agreements. So a surface waiver, I'll say this about these terms. I'm using these terms in this particular way. These are not necessarily terms of art that are commonly agreed on. This is kind of the way I've seen them used, but you could see different variations in these terms being used differently by different parties. But generally, a surface waiver is going to be fairly broad. It's going to, waive all rights to use the surface or a portion of the surface, and they're going to be fairly simplistic, maybe a page or two long. They might include a primary and secondary term, something like that. Whereas an accommodation agreement is going to be far more tailored. These can be very lengthy. These can have a lot of different terms in them. They're going to be heavily negotiated. They're going to include a lot of the same things that you saw in the qualified subdivision statute, which is drill pad size, location, shared use of roads, notice of operation provisions, consents to assign, etc. And both of these obviously are to prevent mineral estate owners from interfering with surface operations, but expect that you're going to have to pony up some cash to get one of these. I mean, very, very rarely is somebody just going to sign one for, nominal consideration these days, especially if they see this going on with their friends and neighbors in the area. They're going to know that they've got a pretty strong bargaining position. And also be aware that operators, mineral owners, operators, the lessees, are under no obligation to sign one of these. They don't have to sign it. They can tell you to take a hike. That is their prerogative to do so. And then you have to decide, is it worth the risk to continue to go onto the surface and conduct these operations, knowing that, there could be an injunction lurking around the corner, or, you could have issues down the road. Now I'm going to turn to a few cases. Again, some of these I'm sure you're probably familiar with, at least in passing. These have been some pretty important cases that have come down the last few years. So one of them was the Lightning Oil versus Anadarko case, and this had to do with drilling a well from an off-lease location or an off-unit location, and what right you had to drill through an adjacent lessee's estate to get to, your lease. So here, Anadarko wanted to drill under the Chapel Wildlife Refuge. They had a lease on the refuge, but obviously because it was a wildlife refuge, they couldn't get a permit to conduct operations, within the refuge itself. So they negotiated with the Briscoe Ranch, which was the adjoining surface owner, to drill through the Briscoe Ranch's land and to reach their leasehold estate. Now, what was going on here was that Lightning actually had a lease on the minerals under the Briscoe Ranch. It was a severed estate. And Lightning was not happy about the fact that Anadarko was drilling through their leasehold. Now, understand, of course, that Anadarko had not fracked anything in this kind of area that was going through Lightning's lease. There was no production going on there. They had, stuck, they had made sure that they had non-perf zones designated, that they were complying with Rule 37, Rule 86, all of that good stuff. And so there wasn't any production happening here. So the issue then was, to what extent does the surface owner have control over what the court colorfully called the subsurface matrix that undergirds the surface estate? So they're talking about the land and the pore space surrounding the minerals, up to and even after the time that the minerals are actually removed from the pore space. So, and again, in Lightning, the surface owner authorized Anadarko via a surface use agreement to drill through Lightning Oil's existing mineral leasehold. And Lightning, of course, sued to enjoin Anadarko from doing so. So the Texas Supreme Court rejected Lightning Oil's argument. They held that the unauthorized interference with the place where the minerals are located only constitutes trespass if the interference substantially infringes on the mineral lessee's ability to exercise its rights. So what the court was saying here was that, look, there's plenty of other areas that you can use to develop the mineral. There's plenty of surface left. There was no immediate signs or plans to use this exact area. It's not like you guys had gone and staked it out or anything like that. So Briscoe Ranch was perfectly within its rights, allowing Anadarko to use its surface estate. Also, they said that, look, this is a narrow wellbore, and your damages would be limited to whatever the tiny amount of minerals that are actually, touched or come into contact with the wellbore. I mean, they said, look, this isn't even a measurable amount of damages. So Lightning was not able to prove that it had specific plans to use that portion of the surface, and any interference was minimal. And the takeaway here is that if no limits are placed on the surface owner may authorize drilling by multiple third parties, which could infringe on an operator's ability to produce their mineral estate. So when negotiating a surface use agreement, again, you're going to want to have language in there that prevents the surface owner from, leasing out portions of the surface or authorizing a surface use agreement on other portions that you think may interfere with your operations. Another case that's commonly cited too is key operating. This had to do with a road. So these were pooled tracts, and the tract that actually had the production on it had a road that stretched across an adjacent tract with no production. This road had been there for a while. They initially had the right to use the road, but what happened was, as production ramped up, the traffic on this road was increasing significantly. The owner got upset about, big trucks rolling through his tract to get to an adjacent tract at all hours of the day and night. He sued to enjoin use of the road. However, the court in Keys said, look, a lessee in a pooled unit has the right to utilize the entire surface of the pooled unit. So it doesn't matter if it's the tract with the actual production, an adjacent tract, etc., or where the well is actually drilled or where the production occurs. You're allowed to use anywhere on the surface of the pooled unit to conduct your operations, as long as they're, reasonable. The primary legal consequence of pooling is that production and operations anywhere on the pooled unit are treated as if they had taken place on each tract within the unit. Essentially, your lease lines disappear when you pool, the tract lines disappear, and it's treated as one large tract at that point. And because production from the pooled part of the contiguous tract was legally producing from the pooled part of the Hegar tract, Key, of course, had the right to use the road to access the pooled part of the contiguous tract. So this is a broad case that expands beyond just the idea of road access and stands more for the idea that there's going to be a broad ability for an operator to use any portion of the surface of a pooled unit to conduct their operations. Quickly here, we're going to have a little interlude. We were told that this is the best way to make sure everybody's paying attention. And this is where you're going to get your credit info. So you will be getting a follow-up email with credit information. It'll come up you should see it in the next week or so. If you look at the downloads section on GoToWebinar, there's a little drop-down menu, and you can get the AAPL affidavit from the handout section. So it's there. You can find it. You can go look for it now if you like. And we won't be sending the affidavit separately, but you will get it when you get the follow-up email. So we promise you, if you don't get it today, that it is coming and you will get to claim that credit. This program is going to be good for 1 credit towards RL, RPL, CPL recertification, credit for ethics recertification, and your component code is here. We've also applied for credit. I think we're pending credit in most of these states, but it's going to be Oklahoma, Texas, Ohio, and Louisiana. NADOA, you're going to be able to claim credit as well, and NALTA as well. And please make sure you stick around and complete our post-event survey after the program has ended. And now back to your regularly scheduled webinar. So another exciting and emerging area of law when it comes to surface use is pore space and underground storage. And this ties into CCS activities, carbon sequestration. You're seeing a lot of this going on in Texas and Louisiana right now. Louisiana is apparently fairly close to obtaining primacy, which means that they're going to be allowed to regulate carbon sequestration activities at the local or at the state level, as opposed to having to go through a complete federal permitting process. So far, the only 2 states that have that are Wyoming and North Dakota, but Louisiana is soon to join the ranks. And so I think we're going to see this ramping up a lot because tax incentives and carbon credits related to carbon capture and storage and sequestration have created a lot of interest in underground storage and injection. Suddenly these empty spaces under the ground are extraordinarily valuable and of a lot of interest, particularly to companies trying to offset their carbon emissions, get carbon credits. And of course, these carbon credits even have quite a bit of value on the secondary market. But the question arises as to who actually owns this empty space or this pore space. So there's 2 general rules of thought on this, and they're known as the American rule and the English rule. And here in America, perhaps not surprisingly, most states go with the American rule. And here we say, the American rule says that the mineral estate does not include ownership of the geological formation or matrix of earth underlying the surface. So the American rule says, look, this empty pore space, empty caverns, things like that belong to the surface owner. They're part and parcel of the surface. The English rule allocates the pore space to the mineral owner. So you can see these are diametrically opposed. There's a few cases, and not a case squarely on point yet in Texas, but a few cases that very clearly point in the direction of Texas adopting the American rule or the majority rule. So the first is the lightning case that we just talked about, where the court said, look, ownership of the surface includes the mass of earth undergirding the surface. So this would include sort of everything surrounding that pore space. In the Humble Oil case, the court said surface ownership includes the matrix of underlying earth. And this means the reservoir, meant the reservoir storage space in that case. In the Springer Ranch case, the court said ownership of the hydrocarbons does not give the mineral owner ownership of the earth surrounding those substances. And, a lot of ways, I think it kind of makes sense because, once a party is done extracting the minerals, they're going to have very little interest, or at least historically, in what happens after that. They're going to go on their way. And the surface owner is really going to be the party sort of dealing with this pore space in perpetuity. So in a lot of ways, it makes sense, I think, that the surface owner should own the pore space, and it should ultimately be the surface owner's decision as to what potentially gets injected into that pore space. So one of the areas that has come up a lot lately is salt cavern ownership. And this is a very interesting area because in this instance, a lot of times these are not naturally occurring spaces. These are spaces that have been created by the activities of a salt mining company. So what's happening here is that there's a lot of underground salt domes that are commonly found on the Texas Gulf Coast and western Louisiana. These are basically just, kind of big uplifts of salt where the salt is close to the surface. It's fairly easily accessible and it's commonly mined. So salt extraction, of course, then, as you take the salt out, it leaves empty space within these domes that are valuable for storage and CCS. And the reason these are so valuable is because they naturally kind of create a barrier or seal that is impermeable. So you can inject gas into these salt domes and the gas is not going to migrate. You can inject, oil into these domes and the oil is going to stay put. So these have become extraordinarily valuable suddenly as we're seeing a ramp up in CCS activities. So back in 1991, there was a case that dealt with these salt domes where the Ninth Court of Appeals held that the owner of a fee interest in salt retains a property interest in the subsurface caverns created by mining activities. So what the Ninth Court of Appeals basically said was that, look, these salt caverns wouldn't exist if it wasn't for the efforts of the salt mining company. Therefore, they should be allowed, since they created the caverns, they've expended a lot of capital creating these caverns, they should be allowed to kind of own the caverns after that and decide what happens with them and reap the benefit of their efforts. And so that was kind of the law for many years, such as it came up, which wasn't that often, but, again, there's a very renewed interest in all of this suddenly, which brings us to the Myers-Woodward case in 2022. And here the 13th Court of Appeals did something completely different. They held the subsurface caverns belong to the surface owner. So they kind of took this American rule majority idea and extended it to say, look, even if the pore space or the empty space was created by the salt mining operations, ultimately it still belongs to the surface owner. And again, I can kind of see this argument because at a certain point, the salt mining company is going to be gone. They're going to be done. Their operations will have ceased. And the surface owner is kind of going to be the one left managing, the surface in this area. And so again, they should probably have some say as to how the land is used moving forward. However, on the flip side, I can certainly see the salt mining companies' argument that, hey, look, we created these mines. These are our mines. We should get to decide what we're going to do with them, particularly now that they have, this kind of unforeseen value. So anyway, in Myers-Woodward, which was a 2022 case, the Court of Appeals declined to follow MAPCO. They treat the caverns artificially created by salt mining efforts the same as naturally occurring pore space. Now, this is currently, because there's this split of authority between two appellate courts, it is currently pending before the Supreme Court. Very good chance the Supreme Court's going to take this case and we will see an update sometime in the next year or so on this one. So then I've got just a couple of minutes left to quickly talk about groundwater and how that sort of ties into this whole idea of surface use and the Accommodation Doctrine. The Accommodation Doctrine applies to owners of severed groundwater estates and not just to the mineral estate. In other words, the Accommodation Doctrine has been extended to include groundwater just the same as it would severed minerals. And this kind of was born out of the Coyote Lake Ranch case, which came out in 2016. So there, Coyote Lake Ranch had deeded its groundwater to the city of Lubbock back in 1953. They had reserved water for domestic use, ranching operations, oil and gas operations, and agricultural irrigation. The city of Lubbock then announced in 2012, so this was many years later, that it suddenly wanted to expand their water extraction efforts. So the ranch had these kind of ongoing rights to use the water for their purposes. And the city came back and said, well, look, we're a bigger city now. We need a lot more water. So we're going to come in and drill 20 test wells. And then we plan to drill another 60 on your ranch. As you could probably imagine, the ranch was not thrilled to hear about this. They opposed these efforts. They cited increased erosion, unnecessary injury to the surface estate, and, not only that, but draining their rights to use the water for their activities. Coyote Lake Ranch argued that the city had a duty to conduct its operations with due regard for the rights of the surface estate. And the city then contended it had the full rights under its deed to pursue its plans, and that the law imposes no duty to groundwater owners as it does on mineral owners. So the city basically said, look, the Accommodation Doctrine doesn't apply here. And Coyote Lake Ranch brought up this phrase that comes up a lot in these cases of due regard. That's kind of the standard for accommodation. There has to be due regard for each other's use. So the court analogized groundwater to minerals in determining the applicability of the Accommodation Doctrine and found that it's no less valid in determining ownership. So the court said, look, it's really the same thing here. It's the same idea. Instead of extracting minerals, you're extracting water, and the two estates have to find a balance between their uses, and there has to be due regard. The court then found that a groundwater owner and a mineral owner are essentially the same, and the accommodation doctrine thus, of course, applies to both. So, this is important because fracking is estimated to use between 70 billion and 140 billion gallons of water each year. This is about the amount of water that Houston and Chicago uses. In some states, such as Texas, the landowners own the groundwater beneath their land. To access the groundwater, it's common for a water use provision to be in the mineral lease or a surface agreement. So again, very analogous to mineral extraction. And there are limits to the landowner's ability to produce groundwater depending on the property location. So this is the idea that, you could be in a conservation district. If it's an aquifer or something like that, there could be other regulations in place that kind of draw the outer boundaries of what you can agree to do when it comes to water usage. So now, and this is the last case I will talk about today. This brings us to the Harrison versus Rosetta Resources operating case. So in this case, Rosetta was pumping water in from another tract instead of purchasing from Harrison. So here, Rosetta was pumping water in from another tract instead of purchasing it from Harrison. And the background here was that there was a prior mineral rights lessee, which happened to be Comstock, that allegedly had caused damage to Harrison's surface estate. They had destroyed a drainage ditch during road construction operations. There was a lawsuit and there was a settlement. Part of the settlement was that Comstock had promised to purchase water from Harrison at a slightly higher rate than the average in the area, which was 50 cents per barrel at the time. Comstock then later assigned these rights to Rosetta. So this is where Rosetta comes into the picture, and they continued the drilling operations, but they said, well, wait a minute, look, we don't think we're bound by this settlement agreement, and your water is really expensive, buddy, so we're going to pump it in from an adjacent tract where we also have rights. Harrison wasn't happy about this because he was getting a lot of value out of Comstock having been using his water. So this is kind of where this case came from. Harrison claimed that Rosetta violated the Accommodation Doctrine by not purchasing the surface owner's water, essentially rendering the surface owner's water well and frac pit useless, diminishing in his eyes the value of his property. And this was, to him, a prior existing use of his property was extracting this water and him getting paid for it. So the court talks about the West Texas rule and says, look, yes, it's customary that an oil and gas lessee would only purchase water from the surface owner of the tract it was operating and not pump in from a neighboring tract unless necessary. But, the parties are free to contract around this. It's not necessarily a hard and fast rule. And here we kind of have this settlement agreement kind of on top of everything. So the court held that Rosetta Resources did not violate the Accommodation Doctrine, and that under the Accommodation Doctrine, the surface owner must prove that the lessee's use of the surface completely precludes or substantially impairs the existing use. This was not the case here, and that the surface owner had no reasonable alternative method available to continue his existing use of the land. So the court said, look, neither of these really apply here. Here, instead, the surface owner didn't really prove the first element, that the use of the surface had precluded or substantially impaired the existing use. The court said, look, you can still produce water from your tract. You can still sell it, In fact, if you were willing to come down on the price, maybe Rosetta would buy it from you. And there's no violation of the Accommodation Doctrine. And the court said, look, an advantageous business arrangement is not necessary use of the surface estate. They said this, this just doesn't fall within the purview of the doctrine. And they said, and I think this is a great quote to end on today. The court said, well, creative, and you never want a court to call your legal argument creative. Usually nothing positive is going to come after that. But the court said, while creative, categorizing refusal to buy goods produced from the land as interference with the land would stretch the Accommodation Doctrine beyond recognition. So they said, look, the Accommodation Doctrine can't just be used in any situation where you can come up with some imaginative way to invoke it. That's not its intent. It's really to balance rights where neither party has much of a choice. And as in many, instances where there's a balancing act, if everybody walks away unhappy, then the Accommodation Doctrine has probably done its job. So since Harrison, surface owners are kind of trying to protect against this a little bit by adding language in-service use agreements that actually require use of water that, on their particular tract and forbid you from bringing it in from another tract. So that is it today. I appreciate you guys joining me. I've enjoyed giving this presentation. I hope you found something useful in it, some new tidbit of information. And if you have any questions and would like to reach out, please feel free to shoot me an email. I love talking about this stuff. I love fielding questions. I usually try to get back to you pretty quickly and really appreciate any feedback. So thanks again for joining. Please take a minute to complete our survey. We really look at that information and take it to heart, and it provides valuable feedback for future presentations. So again, have a great week, and we will see you next time.